Uh-oh. She must have me muted. Maybe she's got me muted.
Yeah, looks like we're waiting for one more person, I think.
Where's my attorney? He's not on here. Is he? What's his name? Michael. I don't see Michael.
I'm here, Steve.
Oh, there you are. Hi, Michael.
Good afternoon, everyone. We're going to go ahead and get started. Does anyone have any questions before we go on the record? Okay.
No questions.
All right, thank you. We are opening the record for the hearing and the appeal of Ledson, Office of Tax Appeals, case number 221111831. Today's date is October 15th, or October 17th, 2024, and the time is approximately 1:32 p.m. Today's hearing is being held by a panel of 3 administrative law judges. My name is Judge Ralston, and I am the administrative law judge who will be conducting the hearing for this case. Also present on this panel are Judge Stanley and Judge Aiken. After the hearing, all 3 judges will confer and produce a written decision. Any judge on this panel may ask questions or otherwise participate to ensure that we have all the information needed to decide this appeal. The Office of Tax Appeals is not a court, but is an independent appeals body, which is staffed by tax experts and is independent of any tax agency, including the Franchise Tax Board or FTB. Also present is our stenographer, Ms. Alonzo, who is reporting this hearing verbatim. To ensure that we have an accurate record, we ask that everyone speaks one at a time and do not speak over each other. Even if you think you know what we're going to ask, please wait for the person to finish speaking so that we can ensure that we have a clear record. When needed, Ms. Alonzo will stop the hearing process and ask for clarification. After the hearing, Ms. Alonzo will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. I'm going to ask the parties to please introduce themselves and state whom they represent for the record, starting with appellant's representative, Mr. Shinner.
Yes, good morning. Good afternoon. Michael Shinner on behalf of appellant Steve Letson, Steve and Amy Letson, the taxpayers.
Thank you. FTB.
Good morning or good afternoon. I'm Sonia Woodruff on behalf of Respondent Franchise Tax Board.
Thank you.
And with me today is Teresa Kayada. She's also representing the Franchise Tax Board.
Thank you. So this hearing is being live streamed to the public and is also being recorded. The transcript and the video recording are part of the public record and will be posted on the Office of Tax Appeals website. That being said, I ask that you please don't show any confidential information on the screen. We held a pre-hearing conference in this matter on September 23rd, 2024, and appellant has submitted exhibits labeled 1 through 13. Ms. Woodruff, did you receive all of the appellant's exhibits?
Yes, I believe I did. They are the same exhibits.
Yes. Well, yeah, Mr. Shinner, are they the same exhibits?
Okay.
And for the record, Mr. Shinner's nodding his head.
Okay.
So yes. And then did you have any objections to Mr. Shinner's exhibits?
I don't have any objections.
Thank you. So the appellant's exhibits 1 through 14 are admitted without objection. And Mr. Shinner, did you receive respondents exhibits A through N?
Yes, Your Honor.
Okay. And just Ms. Woodruff, is that correct? Just exhibits A through N?
That's correct.
Thank you. And Mr. Shinner, did you have any objections to respondents exhibits?
No, Your Honor.
Thank you. Respondents exhibits A through N are admitted without objection. Mr. Schinner, it looks like we have Mr. Ledson here, and he is still planning to testify under oath.
Yes, Your Honor.
Okay. And is that the only witness?
Steve, I assume it's just you and not Amy, your wife. Is that correct?
Yes, it's just me.
Okay, thank you. So, but before we begin, I will swear Mr. Ledson in. And just to double check, Ms. Woodruff, you didn't have any objections to Mr. Ledson testifying under oath?
I do not.
Thank you. So appellant will have 60 minutes to present their case and to provide witness testimony. After that, respondent FTB will have 15 minutes to cross-examine the witness. And after that, FTB will then have 30 minutes for their presentation. And then the appellant will have 10 minutes for a rebuttal. The panel members may have questions at any point during this process. So does anyone have any questions before we move on to our opening presentations? Okay, seeing none. Mr. Ledson, could you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing, excuse me, and nothing but the truth?
I do.
Okay. Mr. Schinner, please begin when you are ready.
Thank you, Your Honor. I don't think we'll be taking a lot of time as allotted. This is really a case more on an equitable basis, and that's why it's important to present Mr. Ledson here. I think the facts are, we're all in agreement. Mr. Ledson made a charitable conservation easement in 2008. He took a deduction as allowed under Section 170 of the Internal Revenue Code. And as you know, there are subject to certain contribution bases. And Section 170 allowed for a 15-year carryover period. At the time of the deduction, 2008, California had still complied or conformed to Section 170 as it existed in 2005, which was a 5-year carryover. But for reasons that, public policy to promote conservation easements, the federal government had extended the 5-year carryover to 15 years. And so the years at issue here are 2013, 14, and 15, which 2013 would have been the last of the 5-year period. And our position is that Mr. Ledson relied on the extension granted under Section 170 and acted in reliance on that. There were collateral materials. I can show you, for example, a link to the California Parks and Service that many sources refer to the charitable deduction that's allowed under Section 170 without specifically referring to the conformity. And I think what we get into with the conformity rules is something that the taxpayer was not aware of this nuance. And again, as an equitable estoppel matter, he relied in good faith on these changes in California's reliance of the conformance to Section 170 and the regulations thereunder. So we're looking for the court to, or this body to recognize that in the interest of good policy, promoting charitable deductions, promoting the conservation easements that Mr. Ledson generously offered to the state, that the state reciprocate and acknowledge that it's a good policy to allow these taxpayers to take the full deduction allowed under Section 170, including the 15-year extension. I'm going to, unless you can advise, are we changing the procedure to allow opening statements now, or should I go right into Mr. Letson's testimony?
Into your opening statement, and then move into your testimony or Mr. Ledson's testimony.
Okay, thank you, Your Honor. I'll now allow Mr. Ledson to provide a general background of the circumstances relating to his property, his charitable deduction, and the situation involving his tax deduction. I think he can give you the mindset that goes into the equitable arguments we were making. So I'll turn it over to Steve to give us the background of this charitable conservation easement.
Thank you, Michael, for that. Just wanted to give you a little bit of background on our family, just brief. Our family came here in the 1860s to California. We have a charitable foundation for children where we've raised millions of dollars to help build playgrounds and on and on and on of things we've done for children here. Besides being assistant to the governor of California and state senators in Nevada and throughout the United States of America in the government, we've worked really hard to try to preserve California's great state, not just in contributing money, but in historical landmarks and anything we could do as a family. I think the family's pretty well known in California. So we were able to purchase a piece of property that's in Sonoma that was going to be subdivided into a bunch of different strange little houses, and the city was all up in arms about it. And they came to me and said, you know, Mr. Ledson, that's a beautiful piece of property. It's got a historic landmark on it. It should be a federal landmark, not just a state, federal city landmark. So I ended up purchasing a piece of property, and lo and behold, when we were under the house, we found a time capsule. And it had pictures from the 1800s. The house was built in 1870. It had all the slides, pictures of San Francisco, but a lot of detail on the house that had fallen off and wasn't available. So we made a lot of pieces for the home and put it back to its original condition. We got a lot of write-ups in different papers. A lot of the people on the city council, the board of supervisors were really impressed with the house. And I was asked to preserve it and make it a historic landmark. So, in working with my accountants and tax attorneys, they explained to me what the benefits and pros and cons would be of that. The property is over 3 acres and it could be 6 lots. As anybody knows, the value of property in Sonoma in California is quite expensive today. But I was willing to give up that because it meant more to me at that time to have this be a historic landmark. I felt like that time capsule and me being able to purchase this piece of property I was given that opportunity. It wasn't just something I had to work for. It was like, here, we want you to do this. So we devalued the property. Not only that, but spent at least $1 million in bringing this house back to its immaculate original condition. And we did that based on what California has done over the years and following the federal government and their deductions for that. If I would have known that anything like this would have happened, probably wouldn't have done it. It seems, my cousin was assistant to the governor of the state of California, so I have a pretty good connection with a lot of different politicians. And I can't really imagine in my mind how the state would not want something like this as a historic landmark. I'm sure you probably have all Googled the property and looked at it on Google Maps and done your study and background on our family and on this property. But it's a beautiful piece of property. People love it. People from all the United States of America come by and view this. There's tours that go by here every day. It's part of Sonoma. It's part of the state of California, and it's part of the United States of America, and I'm very proud of it. I'm here to ask you any other questions, but today I want to ask you to please honor the tax deductions that we've taken. I think we've gone beyond what most people would do with a historic landmark like this. And I'd ask you to really consider what we've done and what I'm asking of you. I'll leave it at that and see if I can answer any questions you might have.
Okay, thank you, Mr. Letson. Mr. Shinner, does that conclude your opening?
Yes, Your Honor.
Ms. Woodruff, did you have any questions for Mr. Letson?
I do not have any questions at this time.
Okay, thank you. Judge Stanley, did you have any questions for Mr. Shinner or Mr. Letson?
No, I don't have any questions. Thank you.
And Judge Aiken, did you have any questions?
Judge Aiken speaking. No questions from me, but thank you for your testimony, Mr. Letson.
Thank you.
Thank you. Ms. Woodruff, you can begin when you are ready.
Okay, good afternoon, and thank you for your time today, panel members. So as you've heard, the question in this case is whether appellants may carry forward their charitable contribution deductions to tax years 2015, 2016, and 2017, all relating back to a 2008 conservation easement. And appellants assert that they should be permitted to carry forward their charitable contribution deductions for 15 years under federal law. However, California never conformed to the federal law that provides for that 15-year carry forward. And so appellants are therefore limited to a 5-year carry forward and may not take deductions for the tax years at issue. Under federal and California law, taxpayers are generally allowed a deduction for any charitable contributions made during the taxable year. Internal Revenue Code Section 170 sets forth the rules for charitable contribution deductions, and deductions for qualified conservation contributions may be found under Section 170H. Appellants claim to have created a qualified conservation easement in 2008. Respondent did not audit that transaction, and so the question of whether this was a qualified conservation easement is not at issue. Really, the sole question is the relevant carry forward period. An appellant's confusion regarding the correct carry forward period is maybe somehow understandable because it relates to a change in federal law that was never made into California law. Prior to 2006, under federal law, individuals could carry forward any excess charitable contribution amounts from a conservation easement for up to 5 years. In 2006, Congress increased the amounts that could be deducted for qualified conservation easements from 30% of a taxpayer's contribution base up to 50%. And as relevant here, it extended the carryover period from 5 to 15 years. The newly enacted IRC Section 170B1E, Clause 2 applied for conservation easements in taxable years beginning after December 31st, 2005. And although that new provision was a temporary provision, Congress extended it periodically over the course of the next 9 years. They permanently enacted the 15-year carry forward as of December 18, 2015. So that is the rule for conservation easement carry forwards for federal purposes. Now, California conforms to the Internal Revenue Code as of a particular date, and that's noted in Revenue and Taxation Code Section 17024.5, which is our conformity statute. And while California law does generally conform to the Internal Revenue Code, it is critical to take note of the specified conformity date because that often can result in a lag or a mismatch, such as here, between California law and federal law changes. So in the case of this extended carryover provision, California never conformed. So for contributions occurring in 2008, such as this one, California conformed to the Internal Revenue Code as of January 1st, 2005. The 2005 code contained a 5-year carryover provision, and so 5 years is the only allowable carryover period here available to these taxpayers. And it is also notable that California never conformed to the new carryover provision in any succeeding tax year. And the reason for this is that the extended carryover was designated as a temporary provision in the Internal Revenue Code. With periodic legislative renewals, but each of those renewals contained a termination date until it was finally made permanent in December of 2015. But because of this lag in California conformity and the termination dates in the Internal Revenue Code, the version of the code California conformed with never contained an active extended carryover. So in other words, by the time California conformed, the termination date had already passed. So for example, in tax years 2015 and after, California conformed to the Internal Revenue Code as of January 1st, 2015. And the code on that date included an extended carryover provision set to terminate on December 31st, 2014. And so California never conformed to the extended carryover provision of IRC Section 170B1E. Now, appellants have argued that respondents' summary of 2015 federal income tax changes states that California actually did conform to the federal law change, and that assertion is factually incorrect. Appellants may be confused by the fact that respondents' federal tax summary describes the federal law rule changes for conservation easements, but the summary then goes on to state that California does not conform to that federal special rule regarding conservation easements. Appellants also argue that California's non-conformity with federal law does not comply with the intent of the federal statute. And, you know, the intent of the federal statute is just not relevant here because California clearly never conformed with the extended 15-year carryover period. So you really do not need to reach statutory intent or construction when the statute is clear on its face. That's all of the comments that I have today, but I'm happy to take any questions you may have at the correct time. Thank you.
Thank you, Ms. Woodruff. Judge Stanley, did you have any questions for respondent?
This is Judge Stanley speaking. I do not have any questions. Thank you.
And Judge Aiken, did you have any questions?
Judge Aiken speaking. No questions from me. Thank you.
Thank you. Mr. Schinner, you can start your rebuttal when you're ready.
Yes, Your Honor, as Ms. Woodruff mentioned, there is a mismatch and a lag with the Franchise Tax Board, the California legislation in terms of its conformity to the federal tax laws. And so this is what creates a situation where the taxpayer is trying to carry out a public deed in reliance on the federal law, not knowing what the California conformity would be other than, as I said, various collateral material, including some of the materials proffered by the respondent's own brief, where they talk about the California generally conforms to Section 170 with modifications. These kind of materials would not indicate to a layperson such as Mr. Letson that there is a mismatch or a lag between the state law and the federal law. In terms of the charitable conservation easement that he generously donated to the state, he was relying on the change to the contribution base as well as the 15-year carryover. As he stated, if he had known that California would not conform and the materials that were proffered by the various public agencies soliciting these kind of charitable donations, he said he might have otherwise not made the donation. So there's an estoppel argument here. Equitably, Mr. Letson relied on these materials in making this donation, and his own advisors at the time touted the benefits he would receive. And I think it would be unfair to penalize him at this point because, as Ms. Woodruff said, there's lags and mismatches between the state and the federal government. Obviously, the law is such as written. He's bound by this. This is an equitable argument that we're arguing the state should be stopped from receiving the benefits of this charitable donation when the reliance, justifiable reliance in Mr. Letson's mind that there would be conformity to the federal government based on the various collateral information he relied upon, that the state should be equitably stopped from denying the 15-year carryover. No further comments, Your Honor.
Thank you, Mr. Schinner. Just give me a second to catch up on my note taking. Okay. Looks like we are ready to conclude this hearing. So today's hearing in the appeal of Ledson is now adjourned and the record is closed. The panel will meet and review the submitted information and send you a written opinion of our decision within 100 days. Thank you, everyone, for attending.
Thank you.
Thank you.
you.
Thank you.
Thank you.